What happened to the Todd Blanche of the Southern District of New York that could convert him into you, someone willing to say the president has both the right and the duty to prosecute his political enemies? I cannot imagine the Todd Blanche of the old days would have ever done that. What happened to you, Todd Blanche?
Senator Adam Schiff of California did not come into this hearing looking for a viral moment. He came in with a record: 3 criminal cases, 1 former client, 1 ethics warning, 1 Department of Justice settlement, and 1 signature. Todd Blanche was not just another Trump appointee. He was Donald Trump's personal criminal defense lawyer in the hush money case, the January 6th case, and the Mar-a-Lago documents case. Then he became the acting Attorney General of the United States. So Schiff started where lawyers start, with dates, with names, with recusals, with the ethics lawyer, with the cases Blanche said he could not touch. Then he moved to the question underneath all of it. When the president's former lawyer becomes the nation's top law enforcement officer, where does loyalty end and public duty begin? Watch how Schiff builds the record.
Thank you, Mr. Chairman. Mr. Blanche, you represented the president in at least three criminal cases: the hush money payment case in New York, the January 6th case, and the Mar-a-Lago classified documents case. You said when you appeared last before this committee you would consult with ethics lawyers about that apparent conflict of interest in handling any case involving the president, having been his personal counsel. Did you consult with Joseph Terrell, a senior ethics lawyer at the department?
I believe I met with Mr. Terrell, yes.
Did Mr. Terrell tell you that ethics laws and policies required that you not be involved in cases involving your prior representation of the president?
Yes.
So in those 3 matters, the hush money payment case, January 6th case, Mar-a-Lago case, you were to recuse yourself?
I'm recused, correct. Well, by the way, the cases are not ongoing, Senator, but to the extent there's any work around those cases, yes, I'm recused.
So you said to CPAC a couple months ago, the other things that are happening, there is not a single man or woman at the Department of Justice who had anything to do with those prosecutions, meaning the prosecution of the president. So you're saying that it's not a conflict of interest for you to be involved in the firing of prosecutors who prosecuted your client, your former client? There's no conflict there? Is that
no, there is. I wasn't involved.
So
that would be a conflict.
At CPAC, you're taking credit for the firing of these Department of Justice lawyers, but you're not willing to take responsibility before this committee. Is that the case?
No.
Okay.
I'm making, I said, there's a
you
statement I gave at
were
CPAC.
bragging about this at CPAC, the firing of these prosecutors, the firing of the FBI agents, the getting rid of everyone who investigated your client. You were proud of that, speaking for the Department of Justice, but you don't think that's a conflict of interest. You moved to vacate, I don't think you're going to deny involvement in this, you moved to vacate the convictions of 12 Proud Boys and Oath Keepers, which erased their convictions, restored their gun rights. These people were convicted in the January 6th investigation, which also involved the president, who you represented. You were involved in dismissing those cases, were you not?
I'm the acting Attorney General, so yes, my department moved to dismiss. I was not involved.
So you didn't recuse yourself from that matter? You were willing?
There's no reason to, from the Proud Boys matter?
Yes,
I mean,
it was.
Lawyer, you know the rules. There are rules that say when I have to be recused, and that's not one of them.
And there are rules, and when you're told to recuse yourself from investigations that you handle for the president, you're supposed to recuse yourself.
No, when I represented the president.
You have also said, you've also refused to release Volume 2 of the Special Counsel's report. That was an investigation into the Mar-a-Lago documents case. How is that not an abundant conflict of interest? Refusing to release to the public an investigative report of an investigation into your client.
I am not a judge. A federal judge.
No. The department's position under you, Mr. Blanche, was do not release the report.
So that position...
If you went into court asking them to release it, it would be released by now. So how is that not a patent conflict of interest?
What you're saying happens to not be true. I did not do that. What you're talking about happened before I became the Deputy Attorney General.
So you support the release of Volume 2?
No, I don't, but I'm recused and had nothing to do with that case.
Schiff does not begin with an accusation. He begins with the rule. Todd Blanche represented Donald Trump in the hush money case, the January 6th case, and the Mar-a-Lago documents case. Then, under oath, he confirms that an ethics lawyer told him the rules required recusal from matters connected to that prior representation. That is the clean part of the record. Then, Schiff moves to the harder question. What counts as connected? If the case is Trump's prosecution, Blanche says he is recused. But when the Department of Justice moves in cases involving Proud Boys and Oath Keepers, defendants tied to January 6th, Blanche says there is no reason to recuse. That is the gap. Then comes the Special Counsel Report, Volume 2, the Mar-a-Lago Documents Investigation. Schiff says the department's position was not to release it. Blanche says he had nothing to do with that decision, and that some of it happened before he took office. But Schiff is not only asking about one court filing, he is asking about a pattern. A former defense lawyer becomes the nation's chief law enforcement officer. The files involving his former client remain controlled by the department he now leads. The prosecutors who investigated that former client become part of the political conversation, and every answer depends on a narrow definition of involvement. That is why this hearing is not just about Todd Blanche. It is about whether recusal is a wall or a loophole.
Yeah, it does matter. We just don't hear much of it from you. But let me ask you about another matter. You have your name on. I don't think you can deny responsibility here, and that is the IRS settlement agreement. So
Yes.
You put your name on this. That absolves the president of tax liabilities in the past. The president was convicted in the case you represented him in of falsifying business records in part for tax purposes. Does this settlement not absolve the president of any liability for tax crimes associated with what he's already been convicted of?
That's not what he was convicted of. It not having to do with
Well,
for tax
I'm happy to
purposes.
read the statement of facts. The participants took steps that mischaracterized for tax purposes the true nature of the payments made in furtherance of the scheme. So you know,
The
Mr.
participant
Blanche,
there was not the president. It was somebody else.
Well, if the president is conspiring with others to falsify business records to help them cheat on taxes, he is also exposed to liability. You know that as well as I do.
He can't be audited for that.
And of course he can be. Of course he can be. And he can be prosecuted for it. But the agreement you signed on behalf of your former client, on behalf of your current client, in a staggering example of self-dealing prohibits that. Let me ask you this. Does this tax agreement, this addendum you signed, also hold him harmless from any audit or tax liability with respect to the billions in crypto money he made in his first year as president?
It's not forward-looking. So to the extent there are taxes filed by the president or his sons or the Trump organization after the date of that agreement, there's no protection.
Well, but before that agreement, so any
So he hasn't filed taxes yet
any-
for money he made last year, right? So
Yes.
no.
So if he
So no protection.
if he filed tax returns this year for money he earned last year, that his sons earned, that his World Liberty Financial, all those people earned and defrauded taxpayers on it, he faces no liability under this agreement you
There's
signed.
no evidence taxpayers were defrauded, and he
But
is not protected.
there's
He
evidence
is
in
not
this
protected.
agreement
He's
that
not
you've
protected.
absolved him of any liability over.
No,
it.
I just said he's not absolved. So the question
So this
was,
agreement doesn't apply to a tax return filed last year
To
or
tax
filed this
returns-
year.
to tax returns filed after the date of the agreement? No,
No,
it does not
before the
apply.
agreement. A tax return filed in this calendar year before this agreement.
Before the agreement, it applies, not after.
Okay, so for a tax return filed this year for last year, for the billions he made, there's no tax liability even if he cheats on his taxes or his kids do or his business do. He is absolved of that further potential liability.
No.
Well, it's in the plain language of your agreement. Did you write this language?
You
by
have
the
to
way?
use the facts, though,
Did
that
you-
he hasn't
did
filed
you-
taxes yet. So when he files taxes, there's no protection based upon this agreement.
Did you write this language?
Did I type it up myself?
Did
No.
you write this language?
No,
Well, you put your name to it.
I did.
So who wrote this?
I don't know the person that actually typed it. I don't know who it is.
Was
Someone
it
within the
was it
Department
one
of
of the
Justice.
president's lawyers, or was it someone from the Justice Department or IRS?
This document would have been
Yes.
somebody within the Department of Justice.
Well, you have no idea who that is.
I don't know the name of the person that typed it
And
up.
did you debate with them the statute of limitations, which clearly would preclude the president's claim, this $10 billion lawsuit?
We had extensive discussions internally about the underlying litigation.
And did you reject the statute of limitations defense?
I I'm not a judge. I don't reject
But
things.
you
I mean,
signed an
there was-
agreement
there
for
was-
the
There was
U.S.
discussion around the
You signed an
litigation.
agreement for the U.S. basically indicating that the Justice Department's position that the statute of limitations applies doesn't matter.
I did. That's not what I said. I didn't
Well-
say that anywhere.
Who rejected the 25 defenses the IRS had to this sham lawsuit? Who rejected them? Who said that these defenses we're not going to accept, we're just going to go with the president's agreement in the slush fund and this immunity?
There was a lot of discussion internally.
But you made the
about
decision.
case. What's the decision? What do you mean?
You made the decision to not defend the IRS and the Justice Department. You made the decision instead to sign this slush fund agreement.
We made the
with
decision to settle the case, correct?
Now the hearing moves from ethics rules to government power. Not a theory, a document, a settlement agreement, a signature. Schiff's argument is that Blanche placed his name on an agreement that, according to Schiff, could shield Donald Trump from tax liability. Blanche disputes that interpretation. He says the agreement is not forward-looking. He says Schiff is not using the facts correctly. He says Trump has not filed those taxes yet, but the question does not disappear, because the problem is not only what the document says in one technical line. The problem is who signed it. Blanche was Trump's personal criminal defense lawyer. Then he became acting attorney general. Then, according to the transcript, he acknowledged that the department made the decision to settle the case. That is the permanent record. Not a tweet, not a cable news argument, a government settlement, a recusal issue, a former client, a sworn hearing, a senator walking through names, cases, dates, and consequences. And this is where the impact becomes real for the people watching. Most Americans do not have a former personal lawyer sitting at the top of the Department of Justice. Most taxpayers do not get a custom legal settlement when the government has potential claims against them. A small business gets audited. A worker gets a penalty letter. A family waits months for an IRS dispute to be resolved. So when the president's former lawyer signs off on a settlement involving that same president, the question is not partisan. It is structural. Can the public trust the referee when the referee used to be on one team's payroll? Blanche's response is that he followed the rules, that Schiff misstates the facts, and that the department made a lawful settlement decision, but he never fully answers the larger conflict. He does not erase the timeline. He does not erase the prior representation. He does not erase the signature. He does not erase the fact that the Justice Department's independence depends not only on legal authority, but on public trust. That is the democratic injury here. The law cannot function if citizens believe it bends around power. Institutions cannot survive if accountability becomes optional at the top and mandatory everywhere else. Schiff's case is not built on volume. It is built on sequence. The lawyer, the appointment, the recusal, the files, the settlement, the signature. And once it is in the record, it does not go away. Power always leaves paperwork.